Final matter come before the court this morning is J.P. Morgan Chase Bank versus Karen Salem et al. It's my understanding that Chase Bank has waived oral argument and the appellant Karen Salem will be arguing this morning. Counsel for the appellant Karen Salem will be arguing this morning.
Good afternoon, Your Honors.
Good afternoon. We've read the briefs and we're ready to proceed when you are.
I see this as an opportunity to answer questions on our thinking. I don't want to take you through the whole thing again. Learning counsel on the other side feels comfortable not being here. The kind of creeping critter in this case for us
I'm sorry, counsel. You may have said it and I didn't hear it. But it's pretty good appellate practice to introduce yourself. I know you're not here, but to introduce yourself and let us know who you are.
It's been a few years. My apologies. Paul Bellamy, and I'm with the law offices of Mark Dan, and we're representing Karen Salem.
Thank you.
The arguments that we raised on the appeal of the confirmation are straightforward. We understand that it's certainly going to be uphill to revisit what has to be an abuse of discretion on the part of the trial court when they decline to grant the stay and accept the deed in lieu of a bond. We wish that the law of Ohio would recognize the special instance of foreclosure. The fact of the matter is most defendants in that situation are going to be judgment-proof. There's not going to be anything to speak of, and the deed to the house is as good as they're going to be able to do in order to get an opportunity to pursue an appeal. We also recognize the law is very clear. It is a matter of discretion. The second argument, of course, has to do with whether or not the holding in Roskowski should be something that has a consequence at the trial level to try and set up a more clear process. We're not claiming in this instance that some shenanigans happened and we got harmed in some sort of way. There is weirdness that we talk about in the distinctions between the two confirmation orders without explanation. But that's the main thing that I think we're trying to make, the main point we're trying to make there. Is there a established opportunity, not in every case, but is there an opportunity with clear timelines, with notice, that allows the judgment debtor to come in and if there are questions about confirmation, raise them in the setting of a hearing? Again, we don't anticipate this would happen most of the time. It does seem to us that if we're going to bifurcate foreclosures and claim that the confirmation process is something that we can actually appeal from, if it's a final appealable order, isn't it important enough to have a hearing when requested to actually delve into what those charges are that are being paid?
And in this case, there was such a request at the trial court level with respect to a hearing on the confirmation. There was something raised timely.
We never filed anything addressing the confirmation. We filed, I think, 2 motions, one to stay the sheriff's sale, one to stay the confirmation of the sale, that were never ruled on by the trial court or effectively overruled. We did not come in and say, we want to have a hearing on this confirmation. We also, however, did not know when the court was going to take the submitted judgment entry and rule on it. It did rule on it, subsequently filed an amended judgment entry. And again, we're not trying to allege any kind of shenanigans. It does seem, however, that it would be more helpful if there was an understanding in the law, whether statutory, local rule, whatever. Here's the deal. The judgment has been taken against you. The confirmation of sale will happen this way. And in this instance, of course, counsel for the lender draws up the entry, and local rule provides that there be some consensus to submit it. If there's no consensus within 30 days, it goes straight to the court. Thereafter, there really are no rules defining time, defining when there would be hearings, what would be required to have a hearing. It's just not there.
I guess the difficulty for this court as a reviewing court is, you know, you're making a very interesting argument about notice and the opportunity to be heard. Problem is, it does not appear that that argument was made to the trial court. So we're in a very difficult position of being asked essentially to rule on it in the first instance.
And to the extent that we would be talking about pre-foreclosure decree, I would say it was pro se. Please extend some. I don't have that. I cannot say that on the confirmation we had been retained. And I, you know, if the court chooses to look at this and just say we can't get to this, so be it. We wanted to raise it. The other argument, if I may, has to do with the mootness theory. The magistrate has suggested that this case might be moot, and in the interest of full disclosure, I checked the docket yesterday, not the docket, but the online version of the docket, and it does appear that something happened yesterday. I'm not too clear what it is, frankly. On June 1st, there's an order of sale returned endorsed, and on 10/24/14 was purchased by Bayview Loan Servicing for $70,000, which we all knew. And the second is a case costed through June 1st, 15, from sheriff sale return. Additional cost $140. I'd hope to get down here in time to actually see what that meant. I do know from a prior conversation with staff at the clerk's office that they anticipated processing paperwork from the sheriff's department, that was going to be the event that distributed the money. So that may be what this means here. I'm not really clear. From our perspective and our argument, that wouldn't make any difference in terms of whether or not we still have a right to an appeal. And the argument is very clearly set forth in Tootin, and our argument against Tootin is very clearly set forth. I don't know if there's anything more that could be said about it. The court's probably aware that we have the Nichols case up before the Supreme Court on a memo, jurisdictional memo. They didn't take it on a conflict basis. So I don't know how the court's going to rule on this. We feel very strongly that there is a right to an appeal, and while we're not saying judgment debtors never have a right to pursue execution, we do feel that the statute is very clear. Execute on it, sell it. By law, the new buyer has a confirmed sale, they're protected. However, that judgment creditor is now still subject to having a judgment taken against them should the judgment debtor prevail. And they'll simply pay it out of cash. There will no longer be a house at issue. But the appeal itself, the right to pursue an appeal doesn't stop. That's our read on the statute. If there's nothing further.
Seeing none, thank you very much for your presentation this morning. This afternoon, the court will take the matter under advisement and issue a written decision. Or, oh, you look like perhaps you weren't finished. Are you finished? Okay. We'll take the matter under advisement, issue a written decision, which we mailed to both sides as well as posted on our website. Thank you. The court is adjourned until Thursday at 7 p.m.